The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 899, coming to you on Monday the 7th of May 2018. On this program, I will speak to you on the topic, the Attorney General's Reference Bill 2018. But before getting into that topic, a few preliminary remarks, beginning as usual with expressions of condolence to all those families which have suffered recent bereavements, and in that connection, the family of the late Granny Rose, who passed away a few days ago at the age, I understand, of 89. The mother of several children, including our celebrated brother, our brothers, I should say, Renwick Rose and Conley Rose. Renwick, I know what it is to lose a mother, as well as Conley and all the other siblings. But you can take comfort from the fact that your mother was a veritable institution in St. Vincent and the Grenadines. I'm sure there will be fulsome tributes to her in due course, and those interested may be able to read some of these tributes in the newspaper. That Granny Rose was a nation builder of class, a humble woman, but one who has touched so many lives in this country for the better. Secondly, I would like to, on my own behalf and on behalf of my own family and chambers, say thank you to Mrs. Sylvia Finley-Scrub, retiring Supervisor of Elections. Mrs. Scrub's tenure of office has been marked by controversy, some of which is still going through the court. But from my own personal experience, the lady has served with great distinction, with great honor and integrity. I've known Mrs. Finley-Scrub long before she became Supervisor of Elections. And on behalf of those who think as I do, thank you, thank you, thank you for your service to this country. And I want to wish all the best to your successor, Ms. Dora James, who I'm sure understands the nature of the responsibilities that she has embarked upon. And I wish her all the very best. Finally, I want to commend to those interested the upcoming training workshop for mediators. If you look in all three national newspapers for last week, Friday, you would have seen an advertisement put out by the Judicial Educational Institute advertising that there would be a training workshop for mediators in St. Vincent and the Grenadines from the 21st to the 25th. Let me just make absolutely sure. Yes, 21st to the 25th of May. Now, the office of mediator has become a very important one in the legal system. Many lawyers have received training and have become certified mediators, but you don't have to be a lawyer to be a mediator. You see, the rules of court provide that where parties to a civil dispute agree to submit the dispute to mediation, there are elaborate rules where the judge can place the case before a mediator. A mediator is like a peacemaker. The mediator attempts to settle the matter between the parties along lines acceptable to the parties. Unlike an arbitrator who hears a matter and comes to a decision based on the facts and legal arguments. Outside the court system, the mediator's role is to encourage people to settle the matters. Going before the mediator doesn't bind the parties one way or the other. You can submit a dispute, both sides, or if there are more than one side, all sides, more than two sides, as many sides to the dispute as there are parties to the case. That can be submitted to the mediator. The mediator will have a conference with two or more sides, and the mediator will encourage the parties to settle the matter. The mediator will hear from one side in private, then hear from the other side in private, and then hear from both sides together, usually without the lawyers being present, but the rules don't say the lawyers can't be there. But I know most mediators prefer the lawyers not to be in the room, certainly at all times, while the mediator tries to coax the parties to settle. If the parties don't agree to settle, that's it. The matter goes back to the judge, and the judge will not hear what happened at the mediation session. No party can bring up at trial the proceedings before the mediator. If you don't agree to settle, that is it. That's your right. But if you do agree to settle, then the judge makes your settlement an order of court. In other words, the judge endorses the settlement you would have arrived at. And then that settlement becomes an order of court and becomes enforceable like any other order of court. In our system, we have several lawyers who are mediators and several non-lawyers. And I tell you, it's a wonderful institution. So for those who have an idea that they may wish to offer their services to be trained, this workshop is coming up 21st to the 25th. You have until the 10th of May to apply to fill out a form and signify your interest. But I would commend the training to all concerned, and it's a wonderful development in the civil justice system. Excuse me. And for parties who have matters before the court, if your lawyer advises you that, look, you should consider mediation, consider it. It saves a lot of time and it saves a lot of money because you don't have to go to a full trial. And the settlement you arrive at is your settlement. That is something that you agree to. If you don't agree, that is the end of the matter. Nobody can force you to agree. All right? Okay, well, let us get into the topic for the evening, the Attorney General's Reference Bill. I happen to have listened to the debate on this bill. I listened on television. You know, Channel 16 brings over the parliamentary debates. I hadn't seen the bill before, and I took particular interest. And fortunately, I think on Saturday night, the Secretary of the Bar Association emailed the bill to all lawyers. And I was very thankful to receive the bill and to look at it myself. And I thought that I would speak on it on tonight's program. And I'm glad I did, because subsequent to receiving the bill, it did come to my attention that there is some controversy over what the bill is and what it is not. And I hope if you are interested and you listen to what I have to say, you would understand, because I'm going to read every word of the bill. It's not long. And I'm going to read it with some comments. And those who have the view that the bill is something draconian and is aimed at taking away your rights and so on, no, nothing of the sort. So let me get into the bill. The full title, well, I better read that as part of the bill. The bill says, this is a bill for an act to provide for the referral of important questions of interpretation of the Constitution and the constitutionality of legislation enacted by Parliament. It reads, be it enacted by the Queen's most excellent Majesty, by and with the advice and the consent of the House of Assembly of St. Vincent and the Grenadines, and by the authority of the same, as follows. Preliminary. Clause 1. This act may be cited as the Attorney General's reference Constitutional Questions Act 2018. Clause 2. In this act, Constitution means the Constitution of St. Vincent and the Grenadines. Counsel means a person whose name has been entered on the roll of attorneys at law in St. Vincent and the Grenadines. Court means the Court of Appeal. So clause 2 is the interpretation clause. Clause 3, referring questions for opinion. The Attorney General may, with the approval of Cabinet, refer to the court for hearing and consideration any important question of law or fact concerning A, the interpretation of the Constitution, B, the constitutionality or interpretation of any legislation enacted by Parliament, and C, any other matter which, in the opinion of the court, ius dem generis with the matters contained in paragraphs A and B, submitted by the Attorney General as an important question. I do believe that a small word is missing from that, namely the word is. This is what it reads. Any other matter which in the opinion of the court ius dem generis with. I believe it should say any other matter which in the opinion of the court is ius dem generis with, but that is something the Parliament could look at when they go into select committee to consider the bill clause by clause. Clause 4, I'll come back and comment on each clause again. So right now I'll just read it through. Clause 4, a question concerning any matter mentioned in section 3 and referred to the court by the Attorney General shall be considered to be a question of public interest or public importance. Clause 5, opinion of the court. Where a reference is made to the court under section 3, the court shall A, hear and consider the reference, B, answer each question so referred, C, certify to the Attorney General its opinion on each question with the reasons for each answer. And the opinion shall be pronounced in like manner as in the case of a judgment on appeal to the court. Excuse me. Clause 6, notice to interested persons. The court has power to direct that any person interested or, where there is a class of persons interested, any one or more persons as representatives of that class shall be notified of the hearing on a reference under this Act, and those persons are entitled to be heard thereon, whether in person or by counsel acting on behalf of that person. Clause 7, appointment of counsel by court. The court may, in its discretion, request any counsel to argue the case with respect to any interest that is affected, and provided that which has not been instructed by an interested person. I'll repeat. 7. The court may, in its discretion, request any counsel to argue the case with respect to any interest that is affected, and provided that which has not been instructed by an interested person. Clause 8, costs and expenses. Subclause 1. The court shall not make an order as to costs unless, for exceptional reasons, the court considers it proper to do so. Subclause 2. The court may, in its discretion, make an order that the expenses incurred for a matter heard under this Act be paid by the Ministry of Finance and shall be a charge on the consolidated fund. Finally, Clause 9. The provisions of this Act do not derogate from the powers of the court under any other enactment. That's it. Passed in the House of Assembly this blank day of blank 2018, and provision for the signature of the Clerk of the House. Objects and reasons. This bill seeks to make provision for constitutional and other questions to be referred to the Court of Appeal by the Attorney General. Signed by Dr. the Honorable Ralph Gonsalves, Prime Minister, Minister of the Public Service, National Security, Legal Affairs, and Grenadines Affairs. So that is the bill. I want to go back now to Clause 7 of the bill because I do believe some words are missing from Clause 7 because as I read it, it doesn't sound complete to me. I'll read it again because you remember I read it a second time when I was going through. Clause 7 says, the court may, in its discretion, request any counsel to argue the case with respect to any interest that is affected, and provided that which has not been instructed by an interested party. So something must be missing from those words because as it is, it isn't clear to me at all. I could understand part of it in that the court may in its discretion request any counsel to argue the case with respect to any interest that is affected. But the other part I don't understand. And provided for that which has not been instructed by an interested party. So I await some clarification, and I certainly will try to be in a position to listen to the debate on the bill when Parliament meets to consider it on that occasion. Now, to me, this is a bill which we ought to have had on the law books a long time ago. I know a similar bill was passed in St. Lucia, under which they were able to refer the very interesting matter of the Privy Council and have debated on it. What it really says is that under the present law, without this bill, the Court of Appeal can only hear an appeal. So that our present Court of Appeal can only deal with a matter where somebody went to the High Court, lost on a point, and wanted to appeal the matter. Therefore, when, as happened a couple months ago, the controversy erupted in Parliament over the question of the vote of no confidence, the Speaker and indeed the government side, and I can't recall if somebody on the opposition side had made the point, all saw the necessity to ask the court the interpretation of the no confidence provisions of the Constitution as reproduced in the standing orders of the House of Assembly. And I am sure I heard the Speaker and the Prime Minister say that it would be a good thing to have the court give an opinion. But under the present laws, the court cannot give an opinion because it has no power just to give an opinion in the absence of a decided case brought to the court upon appeal. That is the Court of Appeal. And therefore, there must be a new law giving the court the power to answer academic questions, as it were. Now, one of the first things lawyers learn at law school is that courts do not give answers to academic questions. In other words, a court doesn't answer a theoretical question or a hypothetical question. A court deals with a controversy. There must be a lis, L-I-S, namely something over which there is a controversy, a dispute between two or more parties. Therefore, right now, you can't just go to court and ask the court, my lord, what does this part of the law mean? You can't do that. There is no law to empower the court to give you an answer. But if you and somebody have a quarrel in the form of a case, and the case goes to the court, both sides argue, the court gives its decision, you appeal the decision, then the Court of Appeal can rule on the dispute in the form of an appeal. So if we want to ask the court what the no confidence provisions really mean, a law has to be passed to give the court the power to deal with a question like that in the absence of a controversy that has gone before the High Court and then comes to the Court of Appeal on appeal. And therefore this bill has become necessary if we want the Court of Appeal to have the power to answer hypothetical questions or theoretical questions. But naturally, you can't have a system where any and anybody could just go before the Court of Appeal and ask the Court of Appeal, I want an interpretation of this or that, I want an answer to this or that theoretical question. And therefore, in St. Lucia and several other Commonwealth countries, there is a law similar to this bill, which is before Parliament, giving the Attorney General the power to ask questions of the Court of Appeal. Now, the bill doesn't interfere with anybody's rights to go to the Privy Council. It doesn't interfere with your rights in an ordinary appeal. And that is what Clause 9 of the bill says clearly. Let me read it again in case you didn't understand. Clause 9 says, the provisions of this act, namely this bill, do not derogate from the powers of the court under any other enactment. In other words, this act does not interfere with the powers of the court under any other laws. It is simply an additional device by which the government, through the Attorney General, and indeed the population, can ask the court, what does this mean in the context of these facts? And allow the Court of Appeal to provide answers. I don't see anything controversial about this at all. In fact, it was a necessary piece of legislation. Excuse me. Necessary and useful. And what I like about it in particular, it allows the court to say that the expenses that any interested party has in instructing a counsel should be paid from the consolidated fund. And therefore it would not be a burden on any interested person. And the way it will operate, whenever a matter comes up, as did the no confidence question, and there is controversy about what a section of the Constitution means, the Attorney General can take it to the Court of Appeal. And people who have different views can decide upon lawyers to argue the matter for them, but the court has to give approval. And the matter is argued fully before the Court of Appeal, and the Court of Appeal gives an opinion as to what it means. Now, it doesn't mean that when that opinion is given, that you still can go to court and challenge some aspect of it. but it simply means that in any future challenge, the Court of Appeal would be fortified by a previous opinion, which itself, when it gives that opinion on a real live issue, depending on what the nature of the matter is, you can still go to the Privy Council with it. And if I think this is a useful and worthwhile piece of legislation, which I look forward to having, hearing the debate, and I look forward to having it passed in the House. So that is all from this program, The Law and You. I look forward to being of further service to you next week, Monday TV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel R. Campbell QC and brought to you on SVG-TV as a public service.